All right, looks like we're live. Let me get the microphone here closer to me. Hopefully this is working this time. Thanks for joining me. This is Freedom is Scary, obviously, and this is Hard to Believe episode number 60. And, this is about really what I probably get the most questions about, the most calls about, and that is basically the right to be a parent and custody questions, family court questions, and what are your rights? And so I have the perfect guest to discuss this with me tonight, and that is one of the hated divorce attorneys around the country. And this is Andy Fox, who is in Tennessee. And what's important about him, I'll bring him right on here, but he is both a patriot and a divorce attorney, believe it or not. And I met him through Daniel Horowitz of the Blaze and the Conservative Review podcast, and had him on here a week or so, or maybe 2 weeks ago. I can't even remember when we were talking with Chris Weiss. So I'll go ahead and bring him right on. But let me give you a quote here. I like to give a quote, and this one pertains to this topic specifically. The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court, meaning the Supreme Court. That was a quote from Troxel versus Granville, United States Supreme Court, in the year 2000. Go ahead and bring Andy on here. Hey, Andy, how you doing?
How you doing? I'm doing well. Yes, sir. Doing well. Thanks for having me on again. I appreciate it.
Yeah, well, I appreciate you coming on. Let me make sure that logistically we're all right here. Can everybody hear us all right? Looks all right. You're already getting questions about ex-wives and $70,000 in back child supports. I appreciate you coming on. I didn't have any particular pointed questions for you. We just kind of wanted to discuss this topic in general. I know because people have a lot of questions about this sort of stuff, and it's just a weird gray area of the law where you have the Constitution implicated, and then you have all sorts of state laws and procedures implicated, and then you have just all sorts of knowledge implicated that some of these divorce lawyers have acquired over the years that people have no idea about. So so you're in was it Knoxville, Tennessee, right?
That's correct. Knoxville. Okay. Eastern Division of Tennessee. Tennessee, of course, has it has four major cities. The three biggest are Memphis, Nashville, and Knoxville. Chattanooga is fourth behind Knoxville, and Memphis is western, Nashville is middle, and Knoxville is eastern. And Eastern Division, they call them the Grand Divisions, the three Grand Divisions of the state. There are federal courthouses in each one of those cities in the Grand Divisions. And I do have to, I'm taking pains to explain this because actually sometimes I'll get calls from people from out of state and they'll say, hey, I have a case in Nashville or Memphis. Is that close to Knoxville? Well, no, it's not. And so you need to explain it for everybody. Memphis is about 5.5 hours away from Knoxville, and Nashville is about 2.5 hours away from Knoxville.
Yeah, I think when I played football at the University of Central Florida, when I first got there, another guy in my class, a young quarterback, he was the same age as me, quarterback, showed up there, and I want to say he was from Knoxville. I can't remember. He was from Tennessee. I remember that. I don't even remember what his name was, but he was a great quarterback.
Do you remember the school?
What's that?
Do you remember the school he was from?
I don't remember. I don't remember. But I guess Tennessee's had a lot of great quarterbacks, just like Florida has. Let's see. And I'll try to pay attention to some of the questions here. Already, do you practice in Florida? I don't think so, right?
No, not yet anyways. Who knows? People like you and me we may end up in Florida the way Florida's going and the rest of the country is going, right?
Yeah, did you watch the UFC fight this weekend? 15,000 people in a stadium in Jacksonville.
I didn't, if I can digress for a moment, I was a huge UFC fan when it was broadcast with Fox or what is it, FS1? Because their business model was giving a lot of free stuff, and then every once in a while you do a pay-per-view. So, and that worked for me. I mean, I watched the free stuff all the time, and I would check in for the, not every pay-per-view, but a lot of them. When it went to ESPN Plus, I don't have a Roku or anything like that, so I was reduced to watching it on like a laptop or computer screen, and it just got I could never keep up with it, so they lost my interest. They lost me as a fan, really. And I feel like ESPN's going back to the kind of giving a little bit of free stuff just on regular ESPN to try to attract people to get onto the pay model. And so I'm getting back into it a little bit.
Yeah, it was. It used to be when I had DirecTV, I just order the pay-per-view through DirecTV, and then of course you could watch the prelims for free on ESPN. And I was a little bit the same way, but actually now that I have it paid for whatever I had to pay for on ESPN, and I also paid for the Fight Pass on UFC. And there's actually a lot of good value there because you can watch all sorts of different fights that would never be on TV with the UFC app. But it's actually pretty easy, just dealing with the app. I mean, the UFC, when all these other sports, just like LeBron James has done in the past few days, I mean, just kind of showed their ass to the entire country and taken political stances. The UFC, meanwhile, is like they're getting down to business. Like the whole country's locked down. A lot of the world's locked down. I mean, and hell, they're in like Abu Dhabi with doing their own thing and chugging through all this stuff. And here they're again like leading the way in Jacksonville this weekend, having like the first real big UFC fight where you have a live crowd. I mean, it's like every seat was full. And I'd posted something on Facebook, I believe it was. Well, yeah, Facebook, saying like I posted a picture of the crowd, and I'm like, look, everything's going to Florida. And rarely they have UFC events in Florida, but everything's going to be in Florida because I mean, you have freedom there. You can't have. I mean, here in West Virginia, we're still locked down. You still have to make an appointment for the DMV, and they're harassing kids just to have kids sports. But in Florida, like you can now go to UFC fight. So yeah, we might have to go to Florida. The problem is they've gotten very good. And I'm not a native Floridian, but I grew up there, went to high school there, got my undergrad degree there. My father was a quarterback for the Gators. I mean, I'm a Floridian, everything except for birth. And they make it absolutely impossible if you have any professional degree to go retire to Florida. I mean, they protect their turf. So there's no like reciprocity from like any state with Florida. You have to go there and you have to turn into a law student again, and you have to take the bar. And say, even if like you or I wanted to go there and just do federal court stuff, that's still the same as we were doing in Tennessee or West Virginia. You still have to you take the Florida bar and go jump through all those hoops. They make it so difficult so that we can't do that. But I guess it's just how much do we want to do it?
So you've inspired me. You know what? I think I'm going to have to go the extra mile here and get back on the UFC bandwagon, because if they're going to, they deserve my viewership, and I need to support them exactly for the reason you stated, that they're leading the charge and they're not letting this lockdown stuff slow them down, and they're not politically correct. And frankly, I'm a boycotter type. So, I've written off the NFL. Now I'm writing off Major League Baseball. I mean, I've been getting into MLB for the past, 6-7 years. I watch a lot of sports when I work out. That's, and that's when I watched a lot of UFC. So you got me all inspired, man. Thank you. I'm going to get back on the UFC bandwagon.
Yeah. If you get the UFC app, and they call it the Fight Pass, I think. I mean, I get it's only the only notification I don't mind on my phone. It actually says like like watch this, pro fight that you'd never heard of. And they're actually like great fights. And the other day I got one that had a female fighting her first pro fight, and we actually knew her because she trains at the same gym that my son does, and we watched her first pro fight. And it wasn't UFC; it was a different group. But that's like the only sport I can stand to watch anymore. Anyways, I always liked to play sports, but I never really got in. Never really was big at watching them, except just maybe the Gators because my father never even liked watching UCF. But UFC, like I really enjoy watching. If you it was $70 this weekend, but not only did you see people enjoying freedom, but you also saw, you saw a guy like break his leg in half on accident. You saw an American girl defeat the Chicoms, dethrone the Chinese champion. And sort of like 1981 hockey versus the USSR, whenever that year was, or 1980. It really is I've really enjoyed watching it. But anyways, yeah, you need to start watching UFC again.
So you saw it was like a Silva back when Silva cracked his leg across what's his name? You know what fight I'm talking about when he gave him a
it was like that, and it was Chris Weidman that did it. Unfortunately,
Weidman, yeah.
it was
right.
It was. I hated watching. I really liked him. I hated to see it happen, but yeah, and it was let's see. Yeah, it was Chris Weidman who was like famous for beating Silva, wasn't he? And that's, God, it was, but the fight of the night for me was they call her Thug Rose beating the Chinese champion, the world champion from China, but they had, they're getting into UFC. They're wanting to take over UFC just like they do everything else in China. And of course, UFC wants to capitalize on that not new market, but really opening up there. So there was a lot of, that's really why I wanted to watch that fight. And it was an amazing fight. She knocked her out with a kick to the face, but yeah, what would you rather watch basketball really other than that? With these spoiled brats that are complaining, though they're multi-gazillionaires, anyways, there's probably a lot of family court and divorce work with those guys as well, I would imagine.
Yeah, they probably have a lot of child support cases, right? Just like the football players. And I see the audience is getting antsy, so let's dive right in. I did want to give a quick disclaimer. Any statements I make on this show are purely for informational purposes and do not constitute legal advice. All right, now we can start talking.
Right. Good idea. Yeah, there's. I'm not sure if Jay. Where'd he go? Jay in particular. He's very critical of me. What's wrong with you? You have no audience because you don't focus on the subject at hand. What does UFC have to do with you're here for? Well, why are you still here, Jay? There's a complaint box somewhere. Just click the complaint box and you can complain to my manager, and he'll look into getting you a refund for the time that you've spent here. So I'm sorry, Jay. Anyways, where were we? So yeah, you're a divorce attorney and you're also a patriot, and you've been, like me, fighting a lot of the fascism that's occurred in the past year. And I guess I'll answer Jay's question first is there a constitutional right to be a parent? I'm sure you've dealt with this, and correct me if I'm wrong, but yeah, every father, mother, parent has a constitutional right to be, an active part of their children's lives. It's protected by the 14th Amendment to the Constitution. And the government, of course, can interfere with it, but they can only interfere in, well, what the Supreme Court calls limited circumstances. But in reality, I think we know that that's a lot of circumstances. But the right to be a parent is a fundamental right.
Yes.
Let's see. Some of the Supreme Court cases: Palco versus Connecticut, 1937. Quilwan, I don't know how you pronounce that. Quilwan versus Walcott, 1978. There's Armstrong versus Manzo, 1965. Santosky versus Kramer. I'm not sure what year that was, but yeah, it's a fundamental right to be a parent, but the court can limit it in certain circumstances, like they can any fundamental right. And what are the state's interests? For instance, in child abuse, does the state have an interest in investigating potential child abuse? Yeah. Does the parent have an interest in keeping their family together? Yes. So the court will look to see if the CPS or DHHR or whoever the governmental actor is, whether they're engaging in a unreasonable intrusion into your right to be a parent, your right to keep your family together, and it's sort of a balancing test. So I mean, let me ask you this first: Have you ever in any of your custody cases or divorce cases, have you ever had to go into the 14th Amendment or federal constitutional rights or due process or anything like that?
Well, in a case recently, I've had to do that because I have a client who's been accused of breaking into his child's mother's residence, and now he had custody of this child. He obtained custody of this child a number of years ago when I represented him, and she got arrested for driving under the influence while the child was in her car. When the child was a toddler, 1.5 or 2 years old, and this happened again a number of years ago. There had been no parentage case. One thing I wanted to say for the audience as well, if I can digress again, is that family law cases are driven almost completely by state law. There are, the provisions stated by the Supreme Court with respect to, the fact that it's a fundamental right, but each state has its own way, its own laws in dealing with these issues. In Tennessee, a mother is the sole custodian of a child unless there's a court order stating otherwise for any child born out of wedlock. Not for if a child's born out of of a marriage, then both parents are considered the natural guardians of the child. But when it comes to children born out of wedlock, which is of course increasing in frequency in these days, the mother is the sole custodian. And the father, if he wants to obtain legal rights, the right to pursue visitation, the right to pursue custody, if the father is more comparatively fit to be the residential the parent of the child, they have to file what's called a parentage case. And this child, they've been living together for some time, and then they split up, and she was the primary residential parent for this child. She was the sole custodian of this child. Well, then she got caught driving under the influence with the child in her car. So, I immediately took the case to the court, filed for an emergency, got custody of the child. And then, as your listeners may know, when you obtain an emergency relief, usually you're going to have a hearing within a pretty quick period of time. In Tennessee, when it comes to temporary restraining orders and things of that nature, you have to have a hearing within 15 days. Now, there's an exception for family law cases, but the judges try to stick close to that particular limitation. So we were showing up for the emergency hearing, and she showed up drunk for that. And I think she got arrested for public intoxication at the courthouse. And so we won that one. And my client went on, of course, to secure custody on a permanent basis. Now, what happened later, though, several years later, is they continued to have an on again, off again relationship. And one day she accused him of breaking into her house and sexually assaulting her, during an exchange or something. Or no, actually the child was at his home, but she was not being faithful. And so, he showed up and caught her. And so this was her response. Well, he got arrested. I mean, in this climate, those types of the pendulum has swung very far towards the victim, the alleged victim, and it's almost in situations like that you have to prove your innocence. So she was able to use that to secure, and I'm getting to the moral of the story here, but she was able to use that to secure temporary custody and retreat, get the child back in her custody. Right now, my client is he is just seeing the child on a supervised visitation basis. And so what happened though is he's got these criminal charges against him. I'm not a criminal defense lawyer really. I do very little of that. And then I'm representing him in juvenile court. But there are delays going on in the criminal side, and he can't. They're still waiting. The prosecution's waiting, I think, to get some tests back, and the Tennessee Bureau of Investigation is very behind on that kind of thing. So he's got these criminal charges hanging over his head, and but the juvenile court hearings keep coming up to be heard. They're trying to say that the child was dependent and neglected in his care. So he's got 2 or 3 different proceedings going on right now. And I wrote a brief saying that the juvenile court hearing cannot proceed until the criminal case is completed, because it's putting 2 constitutional rights up against each other. And in order, if he proceeds, if he has to proceed on the juvenile court case to protect his fundamental right as a parent, then he's giving up his Fifth Amendment right against incrimination, because he's going to have to testify, and then vice versa. So in that instance, recently I have brought up some constitutional issues, and I don't think anybody really wanted to get into it. They just said, do you want a continuance? Okay, here you go. We'll push it on down the road. Nobody's going to complain. But that's really the only instance recently in which I had to bring up constitutional law issues.
Yeah, I had a similar situation that happened locally where there was I don't know that they were married, maybe they were married. No, I don't think they were married, but they had kind of bought a house together and they had kids together. And then they separated, and then there's litigation. And so then the dad at one point comes back to the home to get some of what he claimed was his stuff, and then took his stuff and left. And then the mom calls the cops, and next thing you know, the dad gets charged with a felony, with felony burglary, breaking and entering, whatever it was. And that was litigated, and the judge actually dismissed the charges against the guy because his name was on the deed, though they were separated and there was custody litigation going on. But yeah, this is probably one of the most common ways that people encounter the court system, and inevitably it pisses everybody off one way or the other. We recently had the legislature here in West Virginia enact new legislation, or attempt to enact new legislation that was sort of father's rights, that said that, they kind of took discretion away from the family court to give less time to the dad without, some evidence of really bad conduct or something like. I'm paraphrasing here, but there was a presumption of like 50-50 between the mom and the dad. Because, the family court judges here, as I guess probably everywhere, have the reputation of siding in favor of the moms or favor of the females. Is it that same way in Tennessee? As far as the judges, or people thinking that the judges side with the women versus the fathers?
In a non-domestic violence situation, I think there's a great evolution away from that. Tennessee used to have what was called the tender years doctrine, which has been repealed. It's no longer part of our statutory scheme. And what that used to say, of course, was that a young child, I think 3 years and younger, was automatically placed with the mother. There was a presumption that that child belonged with the mother. That, like I said, that's been repealed. And I'd say in the past 15 years, there's been a very strong move towards a presumption towards equal time. Now, not not officially. Officially, custody is based merely on on a set of factors that are in the statute. In fact, actually, those factors are not comprehensive, but there's about 12 factors that are listed in the custody statutes that give courts guidance in how to analyze a particular case. And there is some language in the statute that speaks to maximizing the amount of time that each parent has, taking into account the factors that are in the statute. But although it's not officially in the statutes, in many of the judges and chancellors' courtrooms, that's the jumping off point. So I think in Tennessee, you have a reasonable chance in most courtrooms of the judge looking at the case evenly, regardless of who's the mother and who's the father.
In Tennessee, are they like specifically like family court judges like we have here?
No. Well, let me take that back. There are some counties that have a family court judge that have been created by private act. For instance, in Knox County, we have one. That's Fourth Circuit Court, and that court's jurisdiction is limited to family law matters. But the some counties you can have, like in Knox County, 3 different court systems effectively. Well, if you want to include juvenile court for children born out of wedlock, you have 4 court systems that you can file a family law case in. You have, well, actually, that's mistaken. Knox County Circuit Court, because this special family court was created, the regular circuit courts do not have jurisdiction over family law matters. So you have Fourth Circuit Court, you have Chancery Court, and you have juvenile court for family law matters of one stripe or another. But divorce cases are usually they're only in Chancery Court or Circuit Court. So Tennessee is an unusual state in that we maintain the distinctions between law and equity to some degree. That also has largely been eradicated. In almost every single case you can file in a court of law, that's Circuit Court, you can also file in a court of equity, which is Chancery Court, and vice versa. There are still a few things that are relegated to one court system or another, but they both have general jurisdiction over divorce. And so what you find is it varies county by county where people will file their cases, and it's really you get to know the particular judge or chancellor in whatever county that venue is going to be in, and you make a decision about, well, I think this judge might be better for this case in this particular circumstance. That's why in Tennessee, at least, it does have value to be experienced as a family law lawyer.
Yeah, I don't know if it's the same way there, but here there tends to be a high number of pro se litigants in the family courts, and the state has actually promoted that over the years to try to make forms available and make it easy as possible for people to proceed without lawyers. And so, of course, then they do that, and that works well until it doesn't, and then the problems pop up, and then they go to a lawyer like after it's too late.
Well, what happens is, yes, the same thing, the same trend is going on, and there's a desire I'll say it's a well-intentioned desire to democratize law for people, because family law cases can be extraordinarily expensive. And although the irony is not for agreed divorces. In fact, I have an associate that works for me, and she handles the agreed divorces, and I think we're probably the cheapest in the area as far as offering agreed divorces, and that's what pro se litigants generally try to pursue. And so they have these forms that are made available to them online, and I guess many have been able to stumble their way through them. But what tends to happen, or what my experience is before COVID hit and courts were, we weren't going into court except by Zoom, is that they would have to come back to court over and over again, because even these forms, lawyers have tried to make forms understandable by laypersons, but still they don't get all the checks right. They don't mark all the boxes right. They leave stuff out. They file the wrong forms. They get something off the internet that's not correct, or it was 3 years old, and so the judges have to spend their time uh, correcting it, but they can't even do that because they can't give them legal advice. But they kind of say, well, you got this wrong, you got that wrong, come again later, and they'll spend a bunch of time while people with paid lawyers are sitting there. The judges will have to spend a lot of time explaining to people where they got things wrong. So it, like any well-intentioned initiative, it really has a lot of unintended consequences that create problems for other people, and don't necessarily serve the people that it's intended to serve.
We had a drunk man on a laptop asked a question. I actually think, I'm not sure if this is what he was talking about, but I think this is a pretty good topic. And his question was, why are lawyers replacing the judges in family court? I'm not sure if he's talking about what I think he's saying, but the way it's gotten in West Virginia is that you don't, in a custody dispute case in family court, you don't really go in and call witnesses necessarily or cross-examine witnesses necessarily. The process that they've created is, and it can be different but with different judges, but they will appoint a guardian ad litem if there's a high conflict custody case, and they'll appoint a guardian ad litem whose job is, as per the order appointing him or her, usually her, to go and make an investigation and then report back with a written report and recommendations to the court, which usually comes in like the day of the hearing or maybe the night before or something like that. And so in lieu of the actual witnesses against the father, or could be the mother, you have basically, we're just all dealing in hearsay testimony. The guardian, can go to the house and look at the house. I mean, there's lots of good things that can be done, but we're basically taking the witnesses out of the courtroom, and we're almost in a lot effectively making like these guardian ad litems, making them like the judge. And I was just in a hearing all afternoon, starting at 1:00 and ending, I think it was like 4:30, of fighting in court over like the world's worst custody case. And it was just the parties were in agreement. The parties were in agreement. It was the guardian ad litem that was determined to make sure that my client did not see his child. And we're fighting the guardian ad litem, and it's been going on for years. And instead of being able to question the witnesses, the only right I have, really, if the court allows it, is for me to cross-examine and question the guardian ad litem. And that brings up a real question to me of federal constitutional rights, of the 14th Amendment, of due process. I mean, if you have a fundamental right to be a parent and you're not even getting a chance the confrontation clause doesn't apply in family court. But I think it's at a certain point you have a due process problem if you're taking a guardian ad litem and making them the judge, and it's all happening on outside of court, and you're not even getting to participate in the process. Is it that way in Tennessee, where you have these guardian ad litems that are kind of taking the place of what used to be witness testimony and presenting evidence in court?
No, in fact, the Supreme Court. I have to give credit where credit is due. The Supreme Court dealt with that issue in Tennessee quite some time ago, actually, and they made it clear in the Supreme Court rules that guardian ad litem serve purely as counsel representing the children's interests. So they're counsel, just like you may be representing the father or the mother. They are lawyers representing the children, and they don't testify, they don't give evidence any more than you and I would give evidence in a hearing. They can offer it, they can cross-examine and call witnesses directly as well, so that you effectively have multiple parties in a hearing in which a guardian ad litem exists, but they do not give reports. Now that used to exist in Tennessee, that format. But like I said, the Supreme Court took that away and really they created the proper role for the guardian ad litem. Now that form of guardian ad litem still does exist for conservatorships, and guardianships as well. Conservatorships in Tennessee are like guardianships for an adult. And guardianships are not intended in Tennessee to deal with dependence and neglect situations. I know in some states, actually, they don't have effectively a dependence and neglect statute, and so they pursue problems with a child's, the parenting of a child in a guardianship petition. I can't remember which state that was, but in my career, I've dealt with somebody from another state. Maybe the people moved to Tennessee, and so we used what's called the Uniform Child Custody Jurisdiction Enforcement Act to domesticate the case into Tennessee. But there are some states, maybe in California, where they don't really have a dependence and neglect statute. Tennessee has a vast set of statutes that deal with children who are in undesirable living situation, and the general term for it is called dependence and neglect, and that's in anytime you have a dependence and neglect case, that's when a guardian ad litem is assigned. It's not, in fact, the Supreme Court discourages the appointment of a guardian ad litem in a divorce case.
Now you're talking about the Tennessee Supreme Court.
That's correct. Yeah, sorry about that. Yeah, in the Tennessee Supreme Court discourages the appointment of guardian ad litems in a divorce case because their policy on that, their belief is generally the parents can be expected to pursue what they believe the best interests of the child to be. Between the two of them, I guess iron sharpens iron, and the best interest of the child is going to be evident to the court. But not so in a dependence and neglect case. In that you have the state, usually it's the state, asserting that the children are not in a edifying living situation, and so that's when the guardian ad litem is appointed.
So you actually have witnesses and cross-examination and all that in regular custody cases in Tennessee.
Yes. Oh yeah. You duke it out. You don't have to rely upon, a report given by some pseudo expert, because there's nothing about going to law school that qualifies somebody to be an expert on what's in the child's best interest, but they can certainly represent their legal interests. And ultimately the court is the one who determines what the child's best interest is, and no longer does a guardian ad litem serve as a mini judge like they used to. I mean, that used to be a problem. And, then, of course, you had the problem of, well, what is the report then? This isn't a legal document. Like you said, it's hearsay. How does this get into the record? How can a judge properly consider what's in this, document, these findings, when it's hearsay? So the Tennessee Supreme Court has done a good job of eliminating that problem.
Yeah, I think this is why think so many calls about people with problems like this, because the state steps in, or a court or a guardian ad litem steps in and causes people to be separated from their children, and people think to themselves, all right, how is this constitutional? I have a civil rights issue here. And that is really a good question. Like, for instance, in this case that I litigated today, of this, it's been going on for 4 years based on allegations. Does CPS get involved? No call to CPS. No call to CPS. Did the police or prosecutors get involved? No criminal allegations, no criminal charges. Basically, we just have one party, and really a guardian ad litem, taking the position that a father can't be around his child. And literally in this hearing, you had a guardian ad litem who's just a lawyer and probably done it quite a few times, arguing with somebody who has dealt with thousands of children over like 30 years of doing this as a career. And so you have a guardian ad litem saying that, well, this person isn't qualified unless they come back with the conclusions that I want them to come back with. And so then you have this being litigated in front of a family court judge. I mean, obviously we have no jury or anything like this. It's up to just the discretion of the judge. But what evidence is being presented? You have a written recommendation of a guardian ad litem, which in this case, there were multiple reports, one of which was like 60 or 70 pages long. I mean, that is a huge guardian ad litem report. And, what do you do? There's full of hearsay testimony. You're not getting to test the credibility of that evidence. And if the judge doesn't allow you to cross-examine the guardian ad litem, then, I mean, you're basically out of luck. So all you can do is ask the guardian, like, look, well, did you talk to this witness, or did you talk to that witness, or why didn't you do this? Why didn't you do that? So you're just stuck attacking their investigation, just like you're attacking the police's investigation. And I'm just wondering, how did we get there? And why do we have family court judges if they're just going to outsource? And I don't know. It sounds like Tennessee had that problem at one time and found a good way to get around it. And like many areas of life, West Virginia has been pretty good at being like 49th or 50th in the country at solving problems. Like they'll get around to it one day. But
well, yeah, you ought to take a look at Tennessee Supreme Court Rule 40 and 40A, because those deal with guardian ad litems in custody cases. And like I said, it's a great innovation. I mean, I give them credit. You still have the problem, though. Well, now, one thing about Tennessee's system that deals with child welfare is that a dependence and neglect case can be filed privately. It doesn't have to be filed by the state. And in that case, of course, when it is filed privately, there was supposed to be a reference to what you call CPS, we call DCS, Department of Children's Services, or the department. But you can litigate a case all the way through without department involvement, and the court will not hold that against you. The court will weigh the evidence on its own merits. I've represented grandparents under those circumstances before, where the department refused to get involved. And it's been some time. I haven't done a lot of that kind of work in maybe 10 years, but in the mid 2000s, I was doing a lot of grandparent representation because they were objecting to the way their grandchildren were being raised. And usually it involves drug use. I mean, that's what it is. Substance abuse leads to almost invariably an inability to live what I call a normal life. In fact, often the deals, if you don't litigate a case all the way to completion, dependence and neglect case, we'll say, hey, let's make a deal. If you can keep a job, live in the same place and pay rent and stay off drugs for a year, we're done. If you can do those things, there's no reason to intrude upon your rights as a parent, because this child is not going to be, under threat. But people that struggle with substance abuse can't make it that long. Typically, they can't even make it 6 months. That's the Department of Children's Services threshold. Usually is a 6-month time frame. If you can do the right thing for 6 months, you got your kids back, we'll leave you alone. And typically people that struggle with substance abuse can only make it about 2 or 3 months. They can only stay off that long before they break down. And I don't know if it's a mental thing or just the temptation of the fix is too strong, but that's been my experience with them.
Yeah, it's a huge problem here as well. And I mean, there are counties in West Virginia, for instance, McDowell County, down the very southern part of the state, of coalfield areas, where the majority of children, I understand, are being raised by grandparents. And I've talked to a lot of them before, but it's really, really sad. And it's brought up a lot of issues of grandparents' rights, and I've dealt with a few of those, and I've actually litigated quite a few of them, because what happens in West Virginia is that the foster system it seems like it's run for reasons, or profit comes into it, I think, or business comes into it, sometimes above and beyond what's best for the kids or the rights of grandparents. And so you'll have kids taken out of the home for drugs, for instance, and instead of placing them with the paternal or the maternal grandparents, they'll go ahead and just place them with a foster family, and they have some sort of contract in place with some middleman organization that places them with the foster family, and the foster family gets, and not all cases, obviously, but I've literally personally experienced cases like this where there's no allegations against the actual blood grandparents, and the children aren't placed with them after being taken out of the home. They're placed just with complete strangers, foster parents. And then the longer they're away, the harder it is to get them back around their grandparents. And the grandparents are forced to file a motion to intervene in the case, and the judge can say no to that. And the only real right they have in West Virginia is to be considered for adoptive placement. And other than that, the department can basically do whatever they want. And there's a whole lot of injustice that happens with that. And I'm sure some of it's through incompetence. And then some of it, I really think has to do with a profit motive. And I don't know of any other really good explanation for it.
That's man, you're making me feel better and better about Tennessee's system. I think now this is, of course, my experience, and my experience is that that caseworkers will attempt to use what they call a relative placement before they try to bring the child into the state custody. So they'll try to find somebody related to the accused parents to place the child with, and they try to keep the children out of the system if they can. Now that's my experience. I'm not saying that's everybody's experience, but in general, I think Tennessee has a pretty good system. There are still times when I feel like they should get involved and they don't. There are certainly times when I feel like caseworkers have gotten involved and they shouldn't. But I'll give them credit. They do try to rely upon relative placements before bringing a child into a system. Many, many years ago, and in fact, before I started practicing law, I worked for state government, and I had contact. My assignment was with Department of Children's Services. I was with the Department of Finance Administration Budget Office, and so I worked with several departments, including one of which was what they used to call Department of Youth Development. And there was a big children back then were heavily institutionalized for reasons other than engaging in juvenile delinquency. They called them status crimes, running away and stuff like that. And there was a big push back in the early 90s to stop trying to bring children into the system, like what you're discussing, and institutionalizing them. And maybe that had some residual effect, because I think that the focus is to try to keep them from having to get into the foster system.
Yeah, in West Virginia, it's a little different. Like the custody cases are litigated in family court, and then the abuse and neglect cases go to the circuit court. And what's happened, and that's the court, that's just like that they would have felony murder trials or felony criminal trials in all civil cases that are not small claims. So what happens is being West Virginia, the abuse and neglect cases just outnumber everything else, and they have statutory priority. So basically, the circuit court judges have, I've heard them complain that they've basically become glorified social workers. That's all they're doing is dealing with day in and day out all of these family issues and custody issues, and looking at drug screens of the parents, and going over these reports of how, status reports of how they're doing and what the plans are moving forward. And meanwhile, everything else is getting on the back burner, including, like I said, murder trials, all felony criminal cases, and much less any, a right-of-way dispute or something that you need to get tried. It's all put on the back burner, and that's completely clogging up the entire circuit court system. And then at the same time, you have the family court judges that handle everything so long as the department isn't filing it. It doesn't make a whole lot of sense, and I don't think West Virginia's got it set up right. But at least in circuit court, you do have witnesses testifying. I mean, you do have that, but then the problem is everyone knows it doesn't matter. Like, you can contest if the department, if the DHHR, CPS, if they're coming after you, they want to take your kids, like, they're going to do it. There's not a whole lot you can do. I mean, you can go through your due process rights. You can make them call witnesses. You can cross-examine the witnesses. You can argue till you turn blue, but everyone knows it's probably not gonna. They're just going through the motions. If the state wants to have you adjudicated of having abused and neglected a child so that they can do X, Y, and Z, then it's going to happen. I don't recall of any cases that I know of where it was like a criminal case where you had a trial and there was an acquittal. I've never even heard of that happening in abuse and neglect case. Maybe it's because they only bring, cases they can prove, really bad cases, or maybe it's just because, that's sort of the system in place that government is set up, and there's no real good way around it without a jury. If you don't have a jury, it's just like criminal cases. If you just had judges deciding these things, you wouldn't have very many acquittals. I don't think. I mean, you'd have some probably, but.
Well, I got a story for you. I actually was representing a young lady. This was years and years ago. And her parents were saying all kinds of things about her to try to justify the court taking her child. And I got in, I was like her second lawyer. I got into the game late. And the grandmother was trying to say that my client had misrepresenting something to a police officer. And it was complicated, but long story short, she was saying that exchange and what happened during that exchange was one of the reasons that they were claiming that they should have custody of the child. Well, it just so happens that the police officer that was involved in that situation was somebody who had been involved in a grassroots guns rights organization that I'd been a part of in the late 90s during the Clinton administration. And, so I used to see this guy at the meetings and stuff. And he happened to be in court that day, too. And I saw him, and I had him come testify. And he said, "Oh, no, that's not what happened at all." What the grandmother was saying. And so I was able, like you said, to get an acquittal. But it was by, it was extremely providential that I had the evidence at my disposal to get that done. That was a great win right there. The other side was stunned that it all worked out, to have him there on the same day, and that I had I knew the guy, and it's like, hey, can you come testify? I saw some interesting topics that we might want to cover real quick in some of the comments, if you don't mind.
Yeah, go for it.
Yeah, so I saw two things that that were mentioned. Number one, somebody wanted us to talk about the 4D system. I don't know if you do child support at all. I can certainly speak about that at length. And then see, what was the other one?
Okay, this one.
Tapping of phones. Now that's something else that I can speak about at length. That reminds me, I did pursue a constitutional rights case with regard to tapping of phones in Tennessee. This was a Tennessee case. This was a person talking about tapping of phones by DCS in Tennessee. So you have at least one Tennessee fan watching right now. And a number of years ago, it came to a client of mine's attention that he had been wiretapped by his ex-wife. And actually, I think they were still married at the time. I didn't represent him at the time, but it came out he had gotten some of the psychologist records, and she had disclosed to the psychologist that she had taped him speaking to his 3-year-old daughter without his consent. So, and that's a violation. Well, it depends on the issue of what's called vicarious consent. I don't know. Have you dealt with some of those wiretapping cases and vicarious consent?
Is Tennessee a one-party consent state or
yeah, yes,
okay.
yeah, one-party consent. So he, in throughout the country, there are two main camps when it comes to vicarious consent. One is that the courts will say, look, there is no vicarious consent exception built into this statute, and we're going to construe the statute narrowly. That's what judges do. They don't create law, and because there is no vicarious consent provision in this statute, we're going to throw out this evidence. Usually there's some kind of wiretapping that's gone on, and it's usually very icky circumstances, like a child is talking to their rapist, like somebody's molesting the child, and this doesn't happen as much anymore because people have cell phones and text messaging and stuff like that. But before the advent of text messaging, this adult will be calling this child, and the parents, like a neighbor or something, and the child might be crying, and parents are like, "What the heck's going on? My child cries every time they talk to Bob down the street." So they would wiretap them and find out that the child is being molested, and so this would create a criminal action, and the courts would then have to rule whether or not this evidence should be excluded because it was obtained illegally. And Iowa was where all this began. I think they were the first state to adopt vicarious consent. But some courts, like Michigan, for instance, and Georgia, they construed the statute narrowly and said, "Hey, look, we don't make law. There's no consent adopted in this statute." And because the wiretapping statutes in almost every state are identical to the federal wiretapping statute, which was created back in the 30s or something like that, and so they didn't think about these issues, and there's no legislative exception built into the statute. But then you have states like Iowa that say, well, we don't care. The parents can consent on behalf of their child. That's what happened here. The child can't consent on their own. They're a minor. They don't have the ability to consent. And, the parents' fundamental rights as a parent give them the ability to consent on behalf of their child. They're charged with the protection of their child. And therefore, we're going to rule that this evidence is not inadmissible because there's been a one-party consent to this conversation. The child consented via the parents through vicarious consent, and therefore, the evidence will be allowed, and it leads to conviction of the child molester. That was the basis under which the case that vicarious consent doctrine first got started. I had a very interesting path, though, or an interesting argument, because we were talking about a wiretapping occurring between, with another parent, with a parent on the other side, versus just some third party that has no rights over the child. That was my argument. It's one thing when you're having parents who are up against somebody who has no rights to speak with the child, no right of society, no right to be with the child. But when you have two parents who both are charged with the responsibility of caring for a child, and they both have the benefit of the society of the child, it's a different dynamic. So I was representing this husband, and we found out that she had wiretapped him during the course of the divorce. And again, I didn't represent him during the divorce, but this was one of those cases that lasted for years and years and years. I mean, they couldn't get enough litigation during the divorce. They had to fight and fight and fight. And in fact, they're still not quite completely finished. But all this happened back in 2009, 2010. And so we filed a claim against her in circuit court, not in the family law court, but in circuit court over the wiretapping issue. We actually had three claims against her. We actually tried. It was a jury trial. We had three claims. One was a defamation claim, as I recall, which it ended up. We thought we were going to have proof for it. We had no proof. We had to dismiss it. One was, another kind of unconscionable conduct claim, which went to trial because she was accusing him of molesting the child. For that, what that led to, that was a very short-lived allegation. It deprived him of his Christmas co-parenting, but it was quickly put down. I mean, there was no evidence for it, but he suffered harm. I mean, it was very agonizing for him to be investigated for molesting his child, and the wiretapping was tangential. It was involved with that. But she, as part of her own investigation, wiretapped him when she was talking to the child. So we tried that case and got a hung jury, decided not to retry it. And we actually took the wiretapping issue to the Court of Appeals, and they dodged the bullet, because I was trying to create a kind of his right to the society of the child versus her right to presumably protect the child. And what they did is they said, look, there's no bright line rule. A child is 3 years old, cannot consent. They don't have the mental capacity to consent to a telephone conversation. So a parent is going to have a right to vicariously consent to their phone conversations at that age. Now, an older child, maybe a 14-year-old child, that may not be the case. But for a child that age, they're going to have the ability to consent. And one factor that I didn't mention was that Tennessee has a parental bill of rights, which allows a parent to have unimpeded conversations with their child. So that was this. I said, look, the legislature's enshrined this right that they can have conversations unimpeded. Well, I mean, if they know that there's a possibility that the other parent's listening on the other side, that's going to be an impediment. That's going to put a cloud over the conversation. They're not going to be able to have a robust relationship, knowing that the other parent possibly is listening in. So those are the two things that we're trying to put together to get some important constitutional premise out of, but it didn't work.
Yeah, and I wonder if that extends to the state. So if the state takes custody, that if they can. So are you saying that Tennessee has adopted this vicarious liability where parents can consent for recordings, or they haven't?
Well, at least that's what I said. They kind of dodged the bullet. They said, well, we're not going to draw a bright line rule here, but certainly for a child that's 2 or 3 years old, a parent is going to have the ability to consent on behalf of them for the purpose of recording conversations, because they just don't have they don't even know what a recording is necessarily. I mean, I guess in this day and age of cell phones, they probably know that, but say if it's a 1.5 year old child, that child's not going to have the ability to consent to phone conversations. So the answer is yes, at least with respect to young children, a parent will be able to consent. And you bring up a great point. If the child's in the state's custody, then I think the state, who's charged with their protection, are going to have the ability to consent to recording conversations between the child and other people, including a parent.
I had this come up to where we're dealing with a baby, and one of the parents actually bugged the room to where the visitation was going to take place. And so they had come up with this recording, and everyone's thinking, all right, well, so obviously they're recording everything, but didn't necessarily assume that they're recording outside of their presence. And and so they ended up bugging a room that the visitation with a baby is taking place, and the other side found it. I mean, they found it. Oh man, there's a recorder in here. What's this doing here? Turned it on. I mean, looked at it, and it's recorded all of their visitations. With the baby, no one in the room. So they call the cops. The cops come. They get the prosecutors involved, and they're ready to charge the other side with a felony, with felony wiretapping.
Mm.
And so that ended up not being litigated, because that provided a pretty good motivation for the other side to relax and sort of back off. The other fairly recent time that I've encountered something like this, and I think the technology is going to cause this to come up more and more, is they have like these new watches and also phones that you can, if you're sending off your kid to go into visitation with the other party, the technology exists to where like the watch or the phone can be called from by a third party, by the other parent, and pick itself up and start recording GPS information and start recording audio. And that brings up all sorts of interesting issues and questions, of, well, what's a felony there, first of all, and what's not, and then what's admissible and all that. I think this technology is expanding so fast. I didn't even know that it existed. In one case I had where even my clients were able to go into this app that they had with their daughter and get this GPS information, and there was an allegation of like stalking or something, and we went back and looked at the GPS information, and it showed exactly where their car was driving, when it stopped, how long it stopped for, what the location was, and how fast it was going. And we were able to use that in court to disprove false allegations of stalking and all sorts of stuff. And I didn't even know that technology existed really at the time. And it's scary to see what what information is being collected at this point. I mean, are you seeing that in your cases in Tennessee of all this new technology being used?
Yeah, I've had a case or two where some, like, well, okay, I had one case in juvenile court. Again, remember, juvenile court in Tennessee is not just the place where dependence and neglect cases are tried, but also where they can adjudicate custody between unmarried parents. And that's a parentage case is what that's called in Tennessee. Now they have concurrent jurisdiction with two other court systems, the Chancery Court and the Circuit Court system. But I think back in the day, juvenile court had exclusive jurisdiction of that issue, but they don't anymore. You can file it in any of three court systems. But I had a case that ultimately we won the case because dad got, I had all this. I spent a ton of money doing discovery on dad. I mean, we went all out, and my client's parents helped her. So we could have gone to trial for days and days, and we ended up winning because on one of the first trial day, dad showed up and he tested positive for meth. So that made for a very easy resolution in that particular case. But in the future, when he was allowed to have supervised visitation with his parents present. And there was a time where mom would send the child with a GPS tracker because she wanted to make sure that they weren't letting the child go off with him. Now I can say all this because at this point he's basically out of the child's life, and so we don't have to worry about that situation arising. But yes, we used it in that particular situation. In Tennessee, though, I'll tell you, the courts, their general disposition towards technology is when the child comes into your home, and I'm talking mostly in a divorce situation, when the child comes into your home, you can do whatever you want with the electronic gizmos that the child brings with them. You can put them in the closet. You can let them keep them going. It's up to you. Tennessee does provide for 2 phone calls per week for the parent who currently does not have physical custody. So if you have a week on, week off child custody arrangement, the parent that does not have physical custody will be able to have 2 phone calls during that week. You can always contract or order to have more, but you have to have at least 2, and there are no rights whatsoever to text, have Facebook messages or anything like that, or even actually there are no rights even right now. We're a little bit behind the times probably to have any FaceTime messages. You can have phone calls. That's what's allowed in Tennessee.
I mean, what are you? I'm sorry. Go ahead.
Well, no, let's finish this. Let's finish this topic before we get to the 4D.
Yeah. Let's see. So as far as, I mean, what's your advice as far as, if people, I mean, I think a lot of this custody stuff, especially with our guardian ad litem type of litigation, it's really turned into, as much as the family courts will let you do, is like presenting screenshots of text from each other or from Facebook Messenger or whatever. And so everybody's saving every screenshot. And there's not a whole lot of phone calls to record necessarily, but I mean, I think it's a good question that people might have is fathers in particular, like what can they do or should they do to protect themselves from false allegations or just to preserve evidence, if they're looking at custody litigation in their future or false allegations in their future. I mean, have you found a way that, is what you think is the best way to sort of, CYA?
Well, I mean, I'll tell you, I have at times advised my client, you better walk around with a tape recorder or a video camera or something like that. And I certainly don't do that in every case, but there have been cases where I've said, you can't take a chance. It's been helpful from time to time. I see Becky Henderson does DHS in Tennessee represent? No, no. The prosecutor's office that prosecutes violations of the general criminal laws of the state of Tennessee do not pursue child dependence and neglect cases. Those are pursued by lawyers that work for the State Department of Children's Services. So those are two separate institutions. I'm not hearing you right now.
Oh, I'm sorry. It's not that way here. I said I'm sure the prosecutors here in West Virginia wish that they weren't responsible for this, but it's the prosecutors that litigate all of the abuse and neglect cases. They don't have any sort of separate counsel for that, which you'd think that it would make sense to separate them.
Man, West Virginia should really take a look at Tennessee's system. I mean, Tennessee's system's not perfect. I get aggravated sometimes by it. Sometimes I think people are treated unfairly, particularly in small counties. I do most of my work in bigger counties, including Knox County, and the counties surround the metropolitan area of Knox County. All of those counties, most of them, not all of them, are pretty sizable, and so I think when you get larger counties, you get more professionalism sometimes. The problem with smaller counties is you'll have somebody who they go to college, they come back, they get a job where they came from, and they didn't like Bobby Sue in high school, and now they have power. And it takes if you have somebody that wields that kind of power and they don't wield it with integrity, you can cause real problems with people. But something like that is not is likely to occur in a bigger county because there's a lot of oversight, whereas in a rural county you may only have one caseworker, and so you better be on that person's good side, right?
And the other thing that I don't know if it's the same way, but it's hard to have accountability in this process, whether abuse and neglect or the family court system, when absolutely everything is confidential. So I've had a lot of people call me about, the judges have issued basically gag orders on the litigants. So I think I talked to one lady who tried to report what had happened to her to like the FBI or something, and the judge actually came down on her for that and says, you're not allowed to release these, confidential proceedings to any social media, to any news media, to anyone. And it was like she had gone to the FBI allegedly. So it creates a process where I think at the very least it perpetuates people believing that it's a corrupt system, that it's protecting itself, and you can't even tell anybody about it because it's just all confidential. And so many other things aren't confidential, but yet we've decided that just even like child support cases in West Virginia, confidential. You can't access the records or release it to anybody, but yet they can charge somebody with a sex offense, make them a registered sex offender, and absolutely every detail of their lives is mandated to be public information. But is it that way in Tennessee, where absolutely everything is confidential related to these?
I just wanted to note, I'm sorry for the inappropriate laughter. I looked at a comment that while you were talking that was a little amusing, but Tennessee, that in fact, you bring to light one of my dislikes about the Tennessee system, and that is that there is no accountability for somebody who wants to abuse the child welfare reporting system. And I've certainly represented people, that have been visited time and time and time again, like because an ex-spouse or, an ex-mother-in-law repeatedly reports them to the Child Protective Services, and they get hassled. And, and sometimes, the CPS people would be like, I'm sorry, I have to do this again. Can I see your house? And they go through that rigmarole. And there's no accountability for people making these false allegations, because all reports to child welfare authorities are confidential, and you can't pierce that. It is an impenetrable wall. There's no way you should go that you can get through it. You can't get through it with discovery. You can't get through it with, the judge won't give you any exception. You will not find out who are making or who is making these false allegations. And generally they occur when there's not even any litigation. I believe that there ought to be some like a government ombudsman that people who are being harassed by the department because of repeated invalid reports, they ought to have an ombudsman that they could go to, who could be empowered to pursue people who are making frivolous allegations. Now, the only place where there's an exception for that is if somebody makes a false sexual abuse allegation. And in that particular situation, district attorneys are empowered to pursue them for that false abuse allegation. But in practice, I don't know if anybody's ever been prosecuted for, making a false child abuse allegation. And by the way, while we earlier discussed that there is a separation between the people that pursue removing custody from parents who have been accused of dependence and neglect, and there's a separation between that and the criminal justice system. When it comes to sexual abuse allegations, there is what is called a CPIT assembled. It's a Child Protective Investigation Team, CPIT, CPIT, that's the acronym. So that's how the district attorney would even be aware of these false allegations, or whether or not an allegation is false. And of course, in child dependence situations, I mean, sometimes the parents are accused of dependence and neglect because they're abusing the child. It's not always, neglect, like, they failed to watch over their child adequately or something like that, or they're constantly suffering from substance abuse. So I mean, criminal prosecutions do result from these dependence and neglect allegations, but they're just, criminal prosecutors are not the ones separating the children from their parents in family court, what you call family court, what we would call juvenile court. Do you want to talk about 4D, or do you want to keep exploring that particular issue?
Yeah, well, yeah, hit that. What is 4D? I've never heard of it.
Well, that's the child support side of family law. The 4D program it's Title 4D of the Social Security Act of 1996, and that was the act that created the centralization, or the central child support receiving units for child support in every state. Every state receives these funds from from the federal government, and as part of the deal to get these federal funds, states had to set up these centralized child support receiving units, and so no longer were counties collecting child support. It was all going to this state entity. And also, as part of this deal, states were required to pursue people not paying child support, to recover, to the extent possible, monies expended for families that were receiving welfare. So, if you're a single mother and you've signed your children up for health care, in Tennessee they call it TennCare, because you meet the means testing requirement, or if you're receiving what do they call it now? It's not AFDC anymore. It's Tennessee assistance, TANF, Tennessee assistance for needy families. If you're receiving some kind of a welfare benefit, then the state is required to pursue child support from the parent who is not the custodial parent. They're going to have a duty to pay child support. So 4D is what created this system. And 4D child support lawyers that are appointed as part of this 4D program to pursue the non-paying or the people that owe child support, they also have to offer their services to anybody. They can't just limit it to people who are receiving welfare benefits. They have to pursue child support on behalf of anyone. So there's not as much outside of divorce cases. People don't hire lawyers to pursue child support as much as they used to. I do get a case every now and then, because when people are part of the 4D system, there are a number. I mean, a 4D lawyer might, and by 4D lawyer, what happens is county by county, they will, at least in Tennessee, they contract either with the local prosecutor's office or private contractors to pursue child support. And so they hire lawyers that's all they do all day long is file child support cases and appear in court on them. And so, they might show up to court with, 30 cases on their docket or something like that. Sometimes people they want a more a personal approach. Maybe they have some unusual aspects to their case. And so, I still get child support cases sometimes where I'm pursuing rather than defending a child support case. But that's what 4D is in a nutshell. It's an attempt to recoup welfare monies expended on behalf of people who should also be receiving child support.
Yeah, it's like a subrogation type of deal
Yes, that's right.
for welfare benefits.
That's kind of what it is. Yeah, that's a great analogy.
Yeah, I dealt with this the other day with a guy that was in the military, and he wasn't even on a birth certificate. Told it wasn't his child. They had been married, but they had the child after the divorce. No mention of a pregnancy, and it was sort of a gray area. I mean, it could have been possible, could have not been possible, and so they came after this guy, and in the end, we got the court to order a DNA test to see whether or not it was actually his child. But the mom didn't even ask for it, just applied for benefits, and then boom, automatically they came after the alleged dad, who wasn't even on the birth certificate of anything. But like everything else, the federal government's gotten involved and dictated, all this stuff, and it's like the size of the federal, the size of the body of like the Federal Register and that controls our daily lives. Like we don't even know. I mean, they have this whole class of lawyers that like most people have never even heard of, dictated by federal law. But here they call it they have a whole bureaucracy around this. They call it the Bureau of Child Support and Enforcement or something like that. And I actually had them come after one time a proceeds from a Section 1983 action where this guy was beat up by police, and we had a good case. It was caught on video. It was in the news. Next thing you know, I get this notice from this bureau of, all right, he's got back child support. And this guy's he's 50 years old or something. So, I mean, this is from 30 years ago. And so with interest, he had a kid, that's now 30 something years old. And so we have this lawsuit that's in the news. And next thing you know, they're serving me with a lien that they got a court order from child support from when this 30 something year old guy was a kid. And with interest, this guy never made any money either. It was just imputed child support. He wasn't involved in it, or they just imputed minimum wage or something for years and years and years. And then they tacked interest onto it. So meanwhile, years later, I settled this case, and it was a 6-figure settlement, a good settlement. And I had to cut them a check before he got $1. And I had to pay all of it with interest and everything. There was nothing I could do. It was crazy. It was the craziest thing. It's like, I was not anticipating that when I filed the lawsuit, that I'd have to be paying off this guy's child support. But what do you know? They're very diligent about that. I mean, they're looking everywhere for child support. Other government benefits, no, they don't care if it ever gets reimbursed. For some reason, they've just got a complete hard on for child support.
Well, no, I'll tell you why. Because they get the states, some of the states' money, some of the block grants are based upon the percentage of recovery, and that's actually created a problem or a controversy in Tennessee over the past 5 years. They were looking to increase their recovery percentage, to get a better, block grant or something from the federal government. And so there were people in the Department of Human Services administration, the bureaucracy, who were wanting to actually lower child support for everybody, so that, because Tennessee has a child support guidelines. It's kind of we have what's called income sharing, where they take the parents' incomes into account and the number of days they spend. Like I say, there are two main variables when it comes to child support in Tennessee: the number of days that each parent spends with the child or children, and then what their incomes are. And they take these two figures, these two variables, and they plug them into an Excel spreadsheet basically, and come up with what your child support obligation is. If you're the it doesn't even matter if you're the custodial parent, because I actually represented a guy one time who was the custodial parent. He had a 2/3, 1/3 time sharing situation. Mom had 1/3, and he was making about $125,000 a year. And she was making about $35,000 a year, and he was going to have to pay her child support because he made so much more money. And that's just how the child support worksheet played out. What happened though was this was like 2007, 2008. He was an architect, and his income went down because of the real estate crash. So he wasn't going to owe her money anymore. And that case went away because she was going to go back to owing him money, and she decided to drop it. But anyways, those are the two main variables. And well, shoot, I forget where I was going with that thing. You have these child support receiving units, though, that their whole goal is to maximize the percentage. And like I said, in Tennessee, what was happening is they wanted to lower child support for everybody, change how the dynamics of this child support calculator, so that they would have a greater recovery rate for the people that they have to go chase down. And that created quite an uproar for family law attorneys, because we're like, hey, and as well as child support referees, magistrates, because they're like, we create child support to help the person who's caring for these children for a purpose, not so the state can maximize its economic block grant recovery, but to help the people who need money to raise children. So it was very interesting to see how these bureaucrats who don't have anything to do with family law trying to drive the amount of child support that people receive so that they could increase their federal grant money. That's an irony for you right there.
Yeah, it's crazy that this whole area of family law and child welfare, all this stuff, it's such a huge body of law. There's so much to know, and it really is. I mean, it's hard to stay on top of it. It really is. What do you think? I mean, you've done this a long time. I mean, what do you think people need? What do you think they need to know that they don't realize about? I mean, so much of child custody litigation is just the facts. I mean, you can't make up your own facts. They are what they are. You can present them. You hire a better lawyer. You can present them in a different way. But what's your advice on what people can do just to, make sure that they're putting themselves in the best position they can if they're looking at custody litigation, that they may not realize? I mean, something that's not obvious.
Yeah. Well, first of all, people need to, I think part of what they need to do is manage their expectations, because this is not the 1950s anymore. And, I still get calls, oh, so-and-so cheated on me. Um, I want to go after full custody. And those, nowadays you can be a bad spouse and a good parent, and people need to come to terms with that and understand that probably if there's been infidelity, it's probably going to have little or no impact on child custody. That's one thing. They need, and then on top of that, they need to understand that family law court is not a place to exact a pound of flesh. Now, I remember one time this was not it was not a case that involved custody, but the chancellor said this is a business deal. Basically, he was saying, we need to get down to talking about what's really at stake here, which is the division of a marital estate. So, don't talk to me about, who done who wrong, is kind of where many judges come from now. They're about, dividing the marital estate up in an equitable manner, and as I said, in Tennessee, and they're not going to get they're not going to be interested in you know going after somebody for their misconduct. That's not going to be an issue. They're not there to say, well, you were a really bad spouse. So I think, managing people's expectations go a long way, and recognizing whether it's just or not just in terms, in moral terms, that being a bad spouse doesn't mean, in the court's eyes, that you're going to be a bad parent. So then you need to, uh, once you can, get that aspect, you can separate those concepts. Then you can start thinking rationally about, what I call the reasonable range of outcomes. That's when I talk to people about their case, like when they come consult with me, I talk about, what the reasonable range of outcomes are, and and the goal is to, get the two parties inside that reasonable range of outcomes, and then you can come to a settlement, and you can do that pretty quickly. A case that starts out contested that settles quickly, you're going to spend $3,000 or $5,000. A case that goes to trial, you're going to spend 30, 50, $80,000 more. I mean, it depends how much discovery you do. So divorce cases are extraordinarily expensive. I recognize that. I hate it, but that's the way it is. And so if you can, if both parties can uh, be, reasonable, then, they can get out of that unfortunate circumstance relatively unscathed. Now, I see somebody mentioning something about parental alienation. Now, see, so much of what drives family law litigation is because you don't have two reasonable people. You have somebody that, maybe they're a narcissist. Um, and um, and so you're not going to be able to settle the case. They have unrealistic expectations, or maybe their lawyer's giving them bad advice, and they don't. Part of a lawyer's job in family law is to manage expectations, and to say, and to help people divorce themselves from emotional attachments, like to a house or something like that. I remember I had a case where I tried. We effectively came out with the same outcome in mediation after a trial. we were say $15,000 into a case, and I had made an offer that said, sell the house, my client will pay alimony of a certain amount for a certain number of years, and we're done. Well, the wife had an emotional attachment to the house because like her dad helped them get the land and he helped build it and blah blah blah. Well, that emotional attachment cost tens of thousands of dollars because she insisted on having the house, and the other lawyer tried to wrangle it in such a way that alimony kind of represented that my client would pay was his share of the house. And I told him, Judge is not going to do that. I don't know why we're arguing this. And finally, at the final argument, my adverse counsel stopped arguing that, and he said, okay, Judge, we're asking for this much alimony. And he realized that that argument just wasn't going to fly. Well, my client had to spend tens of thousands of dollars to get to that point that we could have been at in mediation. So you want to get a lawyer that's going to not tickle the ears of their client, but is going to speak truth to them and help them understand what the reasonable range of outcomes are. And of course, you got to hope that your spouse, your ex or soon to be ex-spouse's lawyer is going to do the same thing, because that's how you can get cases settled in a reasonable way.
Yeah,
did I answer your question? Do you have? Go ahead.
Yeah, I mean, I've told people before, and I think it's true that a good lawyer can be expensive, but a bad lawyer can be even more expensive for both sides. And unfortunately, that's something you don't know necessarily is the other side going to hire a lawyer? And if they do, who's that going to be? Because there are particular lawyers that they could choose who are going to make this process a whole lot more expensive because you can't deal with them. You can't talk any sense into them. And they're always wanting to go down a certain road rather than, really try to work something out. I think I agree as well. I mean, a lot of people, they just want to go in and throw bombs in family court. And I think there's a time to do that, when you have to, when you're backed into a corner. But ideally, you want to work something out before you get into court and not leave it up to a stranger, the judge, to do it. So you use, it's an area of the law where I think good advice can go a long way. And it's not just, pure litigation. There's a lot of just advice to give based on seeing things go wrong so many times. And I think I like the advice about, manage expectations, because everybody has, unreal expectations in that. And I've heard that same thing a lot is I want full custody, I want full custody. And that's just not how it works anymore, not usually anyways. But yeah, I that's just the sort of thing that stuff I was looking for. What if for people in Tennessee, what's the, I mean, who might have some sort of need for your assistance? What's the best way for them to get in touch with you?
AndrewFoxLaw.com is my website. Now I'm in what's called an office sharing association. It's called Gilbert and Fox Law Firm. The guy I practice law with, Roger Gilbert, he does personal injury and workers' comp, so we don't overlap. That's the name of the law firm, Gilbert and Fox Law Firm. My individual website is called AndrewFoxLaw.com.
And this guy Duck asks, how can you win if the game is rigged? And here's what I think is the only good answer to any of this is that, unfortunately, when you have a child with somebody or you get married to somebody, the other party is almost always going to have the unilateral ability to make your life a living hell if they want to. And there's not a whole lot you can do about that. I had one guy represent 3 false allegations of sexual assault of a child, beat all 3 of them, and still has to deal with that person. I mean, the government, the prosecutors, the police didn't do anything about it, didn't punish that person. So all it takes is he said, she said, to really, like I said, make your life a living hell. And the only thing that you can absolutely do to prevent that scenario is to invent a time machine, go back in time and not marry that person or not have a child with that person, which is obviously not an option. So it's just something you have to deal with, which is usually should be great motivation to do whatever you got to do, whether it's by manipulation or just being a nice guy or a nice woman, to keep the other person happy, even if things aren't fair, because they, if they're crazy enough or they go off the deep end, I mean, they can cause you all sorts of problems. But I don't know if you agree with that or
well,
have a different take on it.
One thing I would say is don't, make sure that before you get married, that you spend a lot of time with that person. Don't get married after 3 months or 6 months. Or, I mean, I dated my wife for 4 years before we got married. So, there can be a lot of problems if you don't know who you're getting involved in or involved with on the front end.
Someone had mentioned why get married. I think that's the conclusion a lot of people have come to is they don't get married.
Yeah, of course. I mean, I'm a Christian, so I believe in the biblical family model, and I think that can be a very successful model if both people are oriented correctly. And I think, well, I'll say nature, or I of course, again, I like the biblical model of family, but I think if you even look at people that have not been afforded exposure to that throughout the years have always, the family is the best. The nuclear family is the best model uh, for raising children. And you can look at, like I said, you can look at Eastern Asian countries, Japan and South Korea, that they have that biblical, or they had that model and weren't ever exposed to Christianity. So I think that that's why you get married, because if you want to have children, most people do, that gives them the best opportunity to be successful. It's not perfect. We're in a fallen world, a broken world. Nothing's perfect, but that's the best model you have. And by the way, here's my little phrase I have when it comes to family law cases and court and stuff. It's that court is a terrible remedy, but it's the only one you have. So if things aren't working out, that's what you're stuck with. I did see somebody mention something about mediation. Yes, mediation. People can mediate cases before they file for divorce. In fact, in Tennessee, you have to mediate a case before you can go to trial. You have to mediate a family law case to try to get it to settle. And that can be very, very, very helpful.
Yeah, it's they don't do a whole, they make you do mediation in a car wreck case in West Virginia, pretty much every other kind of case. But I could probably count on one hand the amount of times I've ever seen a requirement to mediate a family law case, whether divorce or custody. And a lot of times there's an informal mediation, just a meeting to try to negotiate things, but nothing with the influence and zeal of an actual, formal mediator. And I think I've realized, if anything else in our conversation here, is that West Virginia has a lot of issues, systematic issues, to use the popular word of the day, that can be easily remedied by looking to a state like Tennessee that's dealt with the same stuff and figured out a better way of doing things. A better way of preserving people's rights, of being more fair and looking after the best interest of the children. But but anyways, probably ought to wrap it up with that.
Sure.
Yeah, I appreciate you coming on to deal with this. It's not the most glamorous topic, but it's probably the one that touches people the most. I mean, it affects them the most. I mean, I know because I get a lot of phone calls, and probably the majority of them have to do with children or custody, or whether from the state or judges or whatever, than anything else. I mean, it really does affect people, like in a wide swath of society.
Yeah. Well, thanks again for having me on. It was my pleasure to carry this conversation on with you, and to hear the differences. And I hope you guys. It sounds like West Virginia has an antiquated system, is how I would put it. They need to modernize.
Well, the funny thing is that we just our legislature just created a intermediate court of appeals because we didn't have one here. And so now we're getting all new judges for this intermediate court of appeals. And that might help this topic some, because I think it might speed up some of the process of all this abuse and neglect stuff that's clogging the systems. But, I don't know how much of many of these reforms have really been brought up to the West Virginia legislature, or whether they know about a lot of these problems. And maybe other people don't agree as much as I do, but I've definitely heard from people, widespread complaints, and I've seen problems myself, like I said, with the whole guardian ad litem system and pretty much everything else that we talked about. So I'll have to take a closer look at Tennessee's laws, and maybe the next legislative session, if it's a shame that they won't rein in our governor, but if they're willing to work on the justice system, then I guess we can tackle that. And also we'll have to talk again about the continued effort at fighting some of these your governor, and as we're fighting our governor over here. And but that's that's just a whole nother video by itself, as you know. But
look forward to it.
Yeah, again, thanks for coming, and have to have you on again soon.
All right.
All right. See you later, Andy. All right. So that was Andy Fox, again, a divorce attorney from Tennessee. And also he's been involved filing a lot of the legal challenges to some of the Tennessee governor's tyranny, which I don't think is as bad as we've been dealing with over here. But he's been, an advocate for our constitutional rights at the same time as sort of working his day job as a divorce attorney in Tennessee. And like I said, this is one of the topics that I hear about most often has to do with, what constitutional rights do you have? What due process rights do you have? Do you have the right to an attorney when they come in and take your kids from you or threaten to? And these are complex topics, and there are answers to a lot of this stuff. There are constitutional rights to be a parent, but it's very limited effect on reality, other than you are entitled to due process and a hearing and all this sort of thing, but you may not like the result of the hearing. But it looks like it's hard to believe that our system is so different than Tennessee. Here in West Virginia, all of my complaints, 70% of them, it sounds like, have been solved or at least made better in Tennessee. And as usual, West Virginia usually runs like 48th, 49th, 50th in solving problems. And this is a problem in West Virginia. Like he said, grandparents raising kids, that's happening a lot in West Virginia. I mean, grandparents are doing a large amount of the parenting in the state because of the drug problem, for any number of reasons, I suppose. But it brings up a lot of constitutional issues, I think, when you have at the same time this foster system, and then you have money being paid and choices of foster parents instead of grandparents. There's lots of complex issues here. Daniel, please do a show on how to gin up civil rights cases against cops. Well, that's pretty much mostly every other show that I do. But this is really an underserved, especially by myself, area of civil rights. And like I said, it's not as glamorous, but it's something, here's the thing. What can you do if there is a 14th Amendment federal constitutional right to be a parent and that the government has to comply with those rights? You can educate yourself on those rights. And I've read some of the Supreme Court cases in the area of parental rights that you can review so that you can conform your conduct with, what the standards are. So that's something that you can do. What else can you do? Let's see. You can make sure that your attorney is able to educate the court on matters of, the fact that you have a fundamental right to be a parent, to have a relationship with your child, to keep your family together, and that there are limitations on a court's ability to intrude into that fundamental right. And it might require, a different strategy. And attorneys can develop ways to present evidence in such a way that you can demonstrate this interference with, a father's right to have a relationship with his child, and that what the government is doing, and it may just be through a family court judge or guardian ad litem, is an interference on that right, the right to exercise your fundamental right to be with your child, to have a family, and keep the government out of it. I mean, the fact is that there's a lot of case law out there on this. The right to raise children as you choose. Meyer versus Nebraska, Supreme Court, 1923. Pierce versus Society of Sisters, Supreme Court, 1925. The right to make decisions about children. Wisconsin versus Yoder, 1972. Troxel versus Granville, 2000, another big one. Again, these are all U.S. Supreme Court cases. Other constitutional protections. Prince versus Massachusetts, 1944. Stanley versus Illinois, 1972. And a lot of times when the courts get into interfering with your right to get married, now they just like to apply it towards the LGBTQ stuff, but it used to apply to just husband and wife being married and have the right to be a family without the government interfering. There's the right to procreate cases. Skinner versus Oklahoma, 1942. Griswold versus Connecticut, 1965. These are all Supreme Court. Einstadt versus Baird, 1972. And of course, Roe versus Wade, 1973. Do you have a right to a lawyer? And not family court cases, but where they come take your kids, abuse and neglect style cases. Yeah. Lassiter versus Department of Social Services, 1981. The court held that parents have a due process right to a fundamentally fair procedure that may require the appointment of counsel. What rights do unfit parents have? Santosky versus Kramer, Supreme Court, 1982. So the U.S. Supreme Court found that even after parents are found unfit in a contested court proceeding, that they still do retain constitutionally protected parental rights. There's other issues you can get into, for instance, with the confrontation clause. If the government comes in and takes a statement from a child, can that be admitted as hearsay evidence, say at a subsequent criminal trial? This has come up before. Confrontation clause and children's statements. There was a U.S. Supreme Court case on this, something versus Ohio. Let's see, what was it? Let me look that up since I mentioned it. Ohio versus Clark. I was close. So when do you have the right to confront your accusers? There's the three-part test. Was it a statement made in the context of an ongoing emergency, investigation of child abuse? Who did the questioning? Was it a teacher or law enforcement? Was it informal and spontaneous? Was there any indication that it was to gather evidence? What was the child's age? So there's all sorts of law out there that's really undertouched because it's not something that's great or necessarily fun to talk about. All right, so thanks for watching, and I'm going to do a video on Wednesday about a topic I much prefer to talk about, and that is about the Second Amendment, because just today the Supreme Court announced, or maybe it was yesterday, I don't know, but the Supreme Court is hearing a Second Amendment case. And so I'm going to have somebody from the Gun Owners of America here to talk about that on Wednesday. So please join me Wednesday night, 6:30, and we'll talk gun stuff. And appreciate you joining me, and appreciate Andy Fox for joining me again. And I'll see you next time to talk about guns.